Is your Second Amendment right to keep and bear arms a fundamental one? Our nation's founding fathers certainly thought so. In the pantheon of rights protected in our Constitution's Bill of Rights, the founding fathers considered it important enough to recognize second, behind only the First Amendment's freedom of speech, religion, and assembly. It was recognized ahead of such fundamental protections as the right to a jury trial, the right against unreasonable search and seizure, and the right against cruel and unusual punishment. As stated by Thomas Jefferson in 1776, no free man shall ever be debarred the use of arms. Even before the Revolutionary War, in fact, Blackstone and other English legal scholars wrote that the right to self-defense is the first law of nature and confirmed the natural right of resistance and self-preservation. After all, what right could be more fundamental than that of self-preservation? Unfortunately, some activists don't consider your right to keep and bear arms fundamental at all. This includes Justice Sonia Sotomayor, who just this month joined the United States Supreme Court. Before her nomination and confirmation, Judge Sotomayor ruled that the landmark D.C. versus Heller decision, in which the Supreme Court overturned Washington, D.C.'s draconian firearm ban, was inapplicable to the individual 50 states. Not only did then Judge Sotomayor determine that the right to keep and bear arms was not fundamental enough to apply beyond the federal government to individual states, her opinion consisted of a sloppy, one-paragraph opinion that ignored over a century of Supreme Court precedent. This is the same type of sloppy legal analysis that led to her one-paragraph decision in the famous New Haven firefighters' affirmative action case. The Supreme Court famously rebuked Judge Sotomayor this summer by overturning her cursory decision, and it will hopefully do so again when it addresses whether the Second Amendment applies to states in the same way that other portions of the Bill of Rights do. But there's good news in all of this. Thanks to the grassroots efforts of people like you, Justice Sotomayor's activist views were exposed and met head-on. She was forced to solemnly reject her own previous inflammatory comments and promise adherence to the text of the Constitution and our nation's laws in order to reach confirmation. And by exposing her views, Justice Sotomayor is the most unpopular justice ever confirmed to the Supreme Court, according to scientific opinion polls. Even among Hispanic Americans, opinion toward the nation's first Latina justice was almost evenly split. What does this mean? It means that Americans, including Hispanics, rejected Justice Sotomayor's brand of identity politics and judicial activism. It also means that people like you spread the message that the liberal judicial activism favored by Barack Obama and Justice Sotomayor is unacceptable. Going forward, this shows the importance of defending the fundamental individual right to keep and bear arms on a state-by-state basis. If we do this, together we can protect every American's Second Amendment right, even if the Supreme Court refuses through raw judicial activism to accept it. It also shows that we must remain vigilant and elect candidates who will appoint and confirm judges who adhere to the text of the Constitution, not their personal political views. Only in this manner can we protect our fundamental constitutional rights, including the natural right to keep and bear arms. That's this week's Freedom Minute.